fixed and stationary. That means, can I have my office in my mobile home? No. Can I have it in my RV? Has to be fixed, and it has to be stationary, and it must be registered. And the registration is transferable, which means if the broker decides to move the main office, which the broker is allowed to do if he or she wants to, they must transfer the registration. And then they have how many days to do so, class? 10 days, very good. Keep the days in mind. The broker has 10 days to transfer that registration. And in the process of moving brokers, what happens to the broker's registration? Anybody remember the term we used in the classroom? It ceases to be enforced. Write it down somewhere. The broker's registration ceases to be enforced, which means that no new business can be conducted. It's in the process of moving. That means the broker has no fixed location and business ceases to be enforced. That means no business can be conducted until the official documents are filed and approved and it's registered with the department. If the department receives it, then the business continues. And they have 10 days to do so. So the broker's main office registration is transferable. And in transferring the registration, to file a change of address is the broker's responsibility, and the broker has 10 days to do so. Branch offices must meet the same requirements, must be stationary, construction, fixed location. And it must be registered. And the registration is not transferable. Keywords, registration for the branch office is not transferable. That means if the broker decides to go to a different location for another branch office, the broker has to register that new location as a new branch office location. And if the broker wants to go back to the previously registered branch office location, the broker can do so, providing the registration is still in force. So if the registration has not expired for the location the broker left in the past, the broker can go back there and start performing the service by just opening doors again, because the registration is still there. Sales associates can be registered from either location. Keywords, the broker can register the sales associates from either location, main office location or branch office location. To give you this scenario, the sales associate frequents the branch office on a regular basis. Where must the broker register the sales associate? From either location, main office or branch office location. That doesn't really matter. It's the broker's choice. When it comes to offices, main office, branch offices, each office must have a sign. And know the sign content. Sign content is important. The sign content, law requires that the entity the broker has registered must be on the sign. The principal broker's name must also be on the sign. And the words license or LIC, real estate broker. Those are mandatory requirements to be on the sign. Those three requirements: entity as registered, principal broker's name, words license or LIC, real estate broker. If the broker chooses to put any other information on the sign, it must be distinctly below. Keywords, distinctly below, not above, not to the side. And if the broker chooses the option of putting the associate's name on the sign for recognition purposes, the broker has to put their full name and their status. Full name and status. Not just whatever the broker feels like putting there for the associate's name. Their full name as registered on their license and the status with the organization. So the public is not confused. But it has to be distinctly below what is required and what is optional. The broker exercises the option, it must be distinctly below. Doesn't have to put any other information on the sign, but if the broker wants to, that's the rules concerning the sign. And also in the broker's office, the broker must display a fair housing poster. Very important, because if the broker does not display a fair housing poster, the broker is guilty of discrimination. That's the only time one is guilty until proven innocent. The law says you're guilty until proven innocent when you don't display a fair housing poster. You're guilty of discrimination. That's why the fair housing poster is an important display that must be in the broker's office. Entity, broker's name, licensed real estate broker. That's all that has to be in the sign. There's no sizing for lettering. The law doesn't put a size to the lettering. It must be readable by the public. It can't be so small that you need a microscope to see it. It doesn't have to be any type of display. It can be as generic as possible on a piece of paper. But that's what it must have. Question to the following is not required to be displayed in a broker's office. Broker doesn't need that. You have your own license. The broker just gets your registration and keep it in a file. There's no requirement to display the associate's license in the office. The law doesn't require that. Advertising. Advertising is a service of real estate. So all forms of advertising for real estate services must have the broker's entity's name. Keywords, broker's entities, not the broker's name. The registered entity of the broker. The only time the broker's name appears is on the sign to the office. That's the only time the public needs to know the broker's name. So any other forms of advertising, promotional items, medium advertising, institutional advertising, specific advertising, must have the broker's entity's name. Entity the broker has registered. And if the associate wants to put their name, which you're allowed to do, they must put their full name. They must put their full name or their last name as per their license. The phone number could be anyone's phone number. The phone number could be anyone's phone number. It doesn't have to be the broker's landline or office number. It could be anyone's contact number. But the broker's entity's name must be in the ad. And one more time, if the sales associate want to put their name, which is optional, they have to put their last name or their full name. They don't have to put the words that they are licensed, just to put their name. If an ad just have a phone number and doesn't have anything else, and the phone number is answered by a licensed individual, it's called blind. Blind advertising is a second-degree misdemeanor. And the broker is the one who will be charged with that second-degree misdemeanor. So those are things that becomes the advertising. Now, let me go through when the associate wants to sell their home and you want to advertise your home for sale. Your question concerning the sales associate who is advertising their home for sale. There are always questions popping up, and it comes in two formats. So the first format is if the sales associate is selling the home as a for sale by owner. You can sell your home as a for sale by owner. And if you're going to sell your home as a for sale by owner and you're advertising the home for sale, you don't have to put that you are a licensee. You can put any information in that ad. You can put anything you want to put because you're doing it for yourself. And you have to disclose when serious negotiation starts. So when one comes to make an offer in your home, you have to tell them that you're licensed. So that's one scenario. Doing it for yourself, you don't have to put your name, you don't have to tell them that you're a licensee. You can put anything in that ad. The time you disclose is when serious negotiation starts. The second scenario is if the licensee lists their property for sale through their broker. Listing the property for sale through their broker, taking out an ad, advertising the home, the regular rules prevail. Like any other rule, you must advertise the home in your broker's entity's name. And if the associate wants to use their name in the ad, they have to use their last name or their full name. They don't have to tell the public that they are a licensee. The only time they disclose is when serious negotiation starts. So those are the two scenarios you will get in your exam. When it comes to advertising your home for sale, when you are doing it for yourself as a for sale by owner, or when you're doing it when it's listed with your broker. The rules are different. The first rule is you can put anything in the ad, you know how to put your name, you can put your first name if you want to, you can know how to put your name, you can put a phone number. But you still have to disclose when serious negotiation starts. If you're doing it through your broker, then the broker's entity's name must be the ad like any other normal ad. And if you want to put your name, which you're allowed to, you put your last name or your first name or your full name. And you don't have to disclose that you're a licensee until serious negotiation starts. So those are the two you'll see on the next time. Question, which of the following applies to advertising? You may put your name, provided you put your last name. It's a requirement. If you do decide, you don't have to, but if you make that decision, the key word in that answer is may. If you want to do it, then you're allowed to do it, but providing you meet the requirements of the law itself. So as we discussed, the last thing we'll do is one of the duties that we as licensee owe to the public. Remember this, on chapter 4, we have to account for people's money. That's what we have to do. Sales associates or brokers, we have to account for people's money. In a separate account. And that account can be in a Florida-based bank, commercial bank, savings association, mutual savings bank, credit union, or trust companies, or a type of company having trust powers, or an attorney as designated by contract. And if the broker is controlling the escrow account, the broker must be a signatory on the account. That's one of the requirements. The broker must be on the signature card. Doesn't necessarily have to sign all the checks. They can designate an unlicensed person to do so, but the broker is responsible. And that account must be reconciled on a monthly basis. Brokers must reconcile that account on a monthly basis for the trust liability of the broker. The broker cannot commingle the funds in that account, but the broker is allowed by law to put up to $1,000 in the account to start and maintain the account for the sales contracts only. For the sales contracts only, $1,000. If the broker is a property manager, the broker is allowed to put up to $5,000 in the account to start and maintain the account and not be charged with commingling. So know the $1,000 amount is on your state exam as recently as last week. $1,000. They ask you that question. How much a broker can put to be charged with commingling? Up to $1,000. According to my intelligence source. $1,000. That's the maximum they can put in the account and not be charged with commingling. Interest bearing, providing that the parties agree, that means the parties to the contract must agree that the money goes into an interest bearing escrow account. So look for that as part of an answer. Yes, it can go in interest bearing account, providing that the parties agree that they go into the account. Both parties, not either party. Keywords, both parties are not either party. If either party agrees, then the broker cannot put that money into an interest bearing account. They both have to agree, and also they must agree who gets the or the beneficiary of the interest. So when the interest is accrued, who gets the interest? So those two things must be met before that money goes into that account. Both parties must agree. Which of the following would be the best definition of escrow? Escrow is always holding something for someone else in trust. Have to be a disinterested third party holding money for someone else. That's what escrow means. Timely deposit is very important. So they always ask you this question, the timely deposit of the money. So, as according to the statute, when the sales associate receives the money from the customer or the client, depends, or the consumer, they must give it to the broker immediately. And the definition by regulation, the rule says immediately is defined to mean by the end of the next business day. Saturdays, Sundays, and public holidays are excluded. The broker's responsibility is the broker's responsibility to put the money into an escrow account, or give it to the title company, or turn it over to the attorney immediately. And the broker's definition of immediately is by the end of business on the third business day from the date the money was received from the customer. 3 business days from the date the money was received from the customer, not counting the date of receipt. 3 business days from that date. And that if the broker deposits the money outside those 3 business days, the broker will be charged with culpable negligence. Keep that word in mind because the exam question is there. The broker who fails to deposit the money in a timely manner will be charged with culpable negligence, and serious consequences will be on the broker's license. Culpable negligence. The broker knows that they have to put that money in a timely manner, and they fail to do so. And that will be the charge the broker will be charged with. Post-dated checks and promissory notes requires the seller's written consent before accepting. And when the sales associate receive these types of deposits, turn it over to the broker, not keep it. The broker has to get control of it. Those post-dated checks and promissory notes is the broker's responsibility to account for it. The sales associate's responsibility is to turn it over to the broker. So they give you those questions on the exam, the broker's away on vacation. You still have to give it to the broker by the end of the next business day. Turn it into the office because every single active broker has an office. Take it to the office, put it in the broker's desk. That's his or her responsibility to take care of it, not yours. Your responsibility is to turn it over to your broker. So immediately means for the sales associate before the end of the next business day. The broker's responsibility is 3 business days from the date of receipt from the customer, not counting the actual date of receipt. So count your days. 3 business days from the date of receipt is the broker's responsibility. 3 business days. So count your days properly. It says associate days has no relation to the broker days. It says associate's days are independent. It says associate days is to the broker. And their responsibility ends there. The broker's responsibility is to take care of it from the time the money is received from the customer. Regardless of who received the money, the broker is responsible. So keep that in mind. If the sales associate loses the money, who's responsible? Broker is. Both taking that trip to Orlando in a minivan. Right? Because it's still the broker's responsibility. Because you are the employee of your broker. And whatever you do, your broker is totally responsible. Just like parents and kids. Finally, if there's an escrow dispute, last we discussed, we go for lunch. People's money, there's always problems sometimes. I know the dispute procedure. There are 2 steps the broker has to perform in order to take care of the dispute. And the first of the 2, and the time to do so is very important. The broker must notify the commission within 15 business days. There's a dispute, whatever the dispute is. Conflicting demand, good faith doubt, there's only 2 the broker has. And the broker has 30 business days to choose one of these 4 procedures. And solve the problem and inform the commission. So 15 days in the first step. 30 business days in the second step, they run concurrently. Brokers, concurrently means the 15 is part of the 30. That means whatever the broker takes in the first step, the remaining days of the 30 the broker has remaining to solve the problem. So there are 4 procedures the broker can choose, the broker's choice. And the first of the 4, any of the 4 that the broker can choose, but we put this in order just to make it a little understandable. The first of the 4 that we have is called mediation. Mediation is a negotiable settlement, may or may not be successful. So the broker can appoint a mediator to mediate a matter between the 2 parties. So mediation is a negotiable settlement. Arbitration. Arbitration is a binding settlement. However, read the question carefully. For the broker to choose arbitration, both parties, buyer and seller, must agree. Buyer and seller must agree that they agree to arbitration because it's a binding settlement. So whatever the arbitrator decides, the parties will agree to it. So the broker has to seek consent from both parties, not either party. So read the question carefully. Okay, the question is there. The broker must get consent from both parties to choose arbitration. Doesn't need the consent of both parties to choose mediation, because mediation is negotiable. But arbitration, they need the consent of both parties. Then we have the litigation procedure. Know the difference. There are 2 parts to the litigation procedure, and they're different. And the first of the 2 is when the broker is not going to claim any part of the money. The broker has the money in his escrow account, want to get rid of it, because the broker says it's not mine. What the broker is going to do is give the money to the clerk of the courts. And that legal process is known as a bill of interpleader. A bill of interpleader is a legal process of the broker taking the money out of the account and turning it over to the clerk of the courts. The broker has no claim of the money. It's not broker's. Broker says, why am I keeping it? If the broker has a claim on all or part of the money the broker is holding in trust, then the broker is going to take the money out of the account, give it to the clerk of the courts, and file for a declaratory judgment. So the broker says, here's the money, but some of it or all of it is mine, and here's my claim. And that claim is known as a declaratory judgment, asking the court to award the broker the money, all or part of it. So those are two parts to litigation. Read the question carefully to make sure you can identify which part of the litigation process that you have to choose. No claim is an interpleader. Claiming is a declaratory judgment. Then we have an escrow disbursement order, an EDL. The broker can request the commission to issue an EDL. And keep in mind that brokers, this is your exam, if the claim is 50,000 or more, the EDO will not want to be one of the procedures the broker can choose, because the commission will refuse the EDO request if it's $50,000 or more. And why? Because in the event that either party sue and they got judgment against the broker, that money comes to the real estate recovery fund. And the maximum the fund will pay out for one transaction is $50,000. That's why they will not approve the EDO request with the possibility of the judgment exceeding $50,000. If the broker requests an EDL and the problem got solved, the broker has 10 business days to advise the commission that the problem has been solved. So know your 3 days. You have 15 business days to advise the commission there's a problem, 30 business days to choose one of these 4 procedures to solve the problem, 10 business days to advise the commission when an EDO is requested and the problem got solved by any other means. Those are the dates. At this point in time, let's go for lunch. I'll see you back here at 1:45.